Hi everybody, thanks for joining me. Alistair Trent, your favorite landlord legal rep here in Ontario, Canada, and today I'm here to make a video about Kiselman and Klerer, which is a decision concerning recovery of damages from former tenants of a rental unit that was released at the end of 2019 out of the Divisional Court in Newmarket. And the case has already caused a good deal of controversy. In fact, I've been asked to make submissions on it in at least one case so far. And the controversy arises, as noted by this commentary by Mr. Zarnet, in that it creates an uncertain pathway for landlords claiming damages against former tenants of rental units. I'll put a link to the CanLII decision, and you can read the article if you're so inclined at the end or at the bottom of this video. So as I was saying, this is a divisional court case out of Newmarket in an action brought by Yuri Kiselman, who was apparently the landlord, against Joel and Pamela Klerer and a couple of businesses that also apparently occupied the premises. It was released November 14th, 2019. And it's of a single judge sitting alone as an appeals court judge in Newmarket. And the reason it's particularly impactful, of course, is that it's an appellate decision. So if you're in small claims court and the decision is presented, small claims court judges may very well feel themselves to be bound by this decision. Although, as I'll get to, there's a wealth of authority that would seem to contradict it. In any case, in this instant case, the appellant was appealing a motion decision of a deputy small claims court judge dated September 5th, 2017, after the tenants made a motion that the court had no jurisdiction and that the matter was one that should have been dealt with by the landlord and tenant board. And in coming to the conclusion he did, the deputy small claims court judge said that there is a wealth of authority provided by the defendant to the effect that the residential tenancies board, which itself is an error, it's the landlord and tenant board, is the forum to go to in a landlord-tenant dispute. They have the expertise and the protocol to deal with these matters. So Mr. Kiselman, who was a landlord, brought a claim against the defendants arising out of their residential tenancy. And he didn't file the claim until some 11 months after the tenants vacated the property. And he brought a claim for $17,000 odd against the tenants, and that included $2,650 in rent arrears, and then a whole bunch of damages that he claimed were a result of the tenant's negligence, categorized in this list here. The landlord on appeal took the position that the order should be set aside and the case should be allowed to proceed based on the fact that the small claims court judge applied the wrong test to determine jurisdiction, and he suggested the proper test was simply whether the damages were undue or not, were the damages caused by the tenants willfully or negligently, and then when did the cause of action actually start. And he then went on to say, upon vacating the premises, the small claims court has sole jurisdiction since the parties were no longer in a landlord and tenant relationship when the breach occurred, and that, as we'll see, is a critical point. And the damages are a result of a cause of action on grounds other than willful or negligent, which is outside the jurisdiction of the board, although that seems to be a difficult statement to reconcile with the past statement that the damages were in fact caused as a result of the tenant's negligence. But nevertheless, the tenants took the position that the landlord and tenant board had exclusive jurisdiction to determine applications over which it had jurisdiction pursuant to the Act, which provides that the board has exclusive jurisdiction to determine all applications under this Act, and with respect to all matters in which jurisdiction is conferred on it by this Act. And I guess really the only way to make sense of this decision is to suggest that the court took a sort of disjunctive reading of this section to say that not only does the board have exclusive jurisdiction to determine applications under the Act, but also with respect to any subject matter jurisdiction that's conferred upon it by the legislation, namely rent arrears and damages. and then the tenants went on to say that the exclusive jurisdiction means that if a matter is within the jurisdiction of the board, then no other court or tribunal can have jurisdiction over the matter. Simply put, if the board's exclusive jurisdiction is triggered, the court's jurisdiction is ousted. And that's been a well-settled and long-standing principle that is recognized in Ontario for a significant period of time, that the board has exclusive jurisdiction. But in order for the board to have exclusive jurisdiction, it has to have jurisdiction in the first place. And that's where we get to the controversy. And beginning the analysis, the appeal court cites section 89(1) of the Residential Tenancies Act, which provides that a landlord can apply to the board requiring a tenant to pay reasonable costs for damaged property if the tenant, another occupant, or a person whom permits in the residential complex willfully or negligently causes undue damage to the rental unit or the residential complex, and the tenant is still in possession of the rental unit. And that's really the determinative issue, which the court seems to have, in my respectful submission, overlooked, in the sense that the landlord can only apply to the board where the tenant is in possession of the rental unit. It doesn't matter if the tenant subsequently vacates the rental unit, provided that the application is commenced where the tenant is still in possession. The court then goes on to set out the monetary jurisdiction of the board, which at the time this action was filed was $25,000. It's now $35,000, but in any case, the claim was within both the jurisdiction of the landlord and tenant board and in the court, as it totaled $17,000 and odd dollars, including both the rent arrears and the damage to property. Now, here's where the problem arises, because the court then goes on to cite a number of decisions where the board's exclusive jurisdiction was upheld and the court's jurisdiction was ousted. And they're Mackey versus City of Toronto, Fong and Lemieux, and Efrach and Cherish Home Living. And the problem with all of these cases is that they were cases brought by tenants against the landlord for alleged failure to repair or maintain the property. And the Residential Tenancies Act, in fact, allows former tenants to apply against their landlords for up to a year after they've left the property, or more particularly, a year after the problems occurred, even if they've left the property. Whereas a similar ability doesn't exist for landlords. As we've seen back in section 89, the landlord may only apply to the board where the tenant is still in possession of the rental unit, as distinct from tenants who can apply after they leave. And in this regard, this is where I really think the problem has occurred in this case, is that he's applied a number of cases dealing with tenants' claims, which are permissible after the tenant leaves, and then applied that to a landlord's claim, which cannot be brought after after the tenant leaves, rather. And as we've already seen, whether or not one can apply to the board is determinative of whether the court has jurisdiction or the board has jurisdiction. So in conclusion, he holds that the landlord brought a claim in small claims court for rent arrears and damage to property after the tenant has vacated the property, and because the amount of the claim didn't exceed the $25,000 cap that was in place, it's plain and obvious that section 18068(2) of the Act gives the board exclusive jurisdiction to determine claims of this type between landlord and tenant. And of course, that's in fact true, as long as the tenant's in possession. And the parties had a landlord and tenant relationship, and in my view, nothing turns on the fact the action was started after the tenant was no longer in possession. And in my respectful submission, that's really where the error in this decision lies, because once again, we've seen that the landlord can only make the application when the tenant is in possession of the rental unit. If the tenant has gone out of possession of the rental unit, then the board cannot entertain the claim, and it has no jurisdiction. Because the board has no jurisdiction, the court's jurisdiction is triggered and the landlord has to sue in the courts. He also goes on to say that it's clear that disputes of this sort are the daily fare of the landlord and tenant board. When assessing claims, the board is in the best position to determine whether claims for rent arrears and allegations of damage to property against the tenant amount to undue damage or simply wear and tear as a result of the normal occupancy of rental unit. And again, that's a statement with which I would generally agree. In fact, it's a general premise of administrative law that where the legislature sets up a given administrative scheme or adjudicative process to resolve specialized matters of public policy, such as landlord and tenant, immigration, human rights, etc., that the court should decline to exercise its jurisdiction in favor of the specialized adjudicative forum. And while I wouldn't take any issue with that, the fact is that in the case where the tenant has left possession, it's clear that the landlord can no longer apply to the board, in which case the jurisdiction of the court is triggered. There are a number of cases recently, mainly out of Kitchener from one particular small claims court judge, that have been flowing more in this direction and importing a discoverability test to the whole situation, to the extent that if the damages could have been discovered or were discovered while the tenant is in possession, then the landlord was obligated to make application to the board and can not wait for the tenant to leave and then apply to the court. And again, that is another sort of situation with which I disagree, and I'd favor the traditional test, which is simply that where the tenant is in possession, the board has jurisdiction and you can apply to the board, and where the tenant is left, then the board no longer has jurisdiction as far as landlords are concerned, and the landlord must apply to the court. There are any other number of other decisions, both at this level in the divisional court and in the Court of Appeal, that reiterate the traditional test being in possession or out of possession. And it's important, if you're faced with this decision as a landlord, to be able to effectively argue the contrary cases and point out why this decision is, again, in my respectful view, somewhat in error and internally inconsistent. On top of that, if you require any assistance dealing with this type of a dispute or any other type of landlord and tenant issue in Ontario, I would encourage you to call my office at 416-628-4835 or visit my website at www.investrent.ca. And thank you again for joining me, and I hope you found this informative. I welcome any questions or commentary you may have.